Mesdames et messieurs,
Ladies and gentlemen, I now call this meeting to order of the Standing Committee on Citizenship and Immigration. Today we will be continuing our study on strengthening the protection of women in our immigration system.
Of our meeting, we have with us by video conference the Ministry of Businesses, Innovation and Employment of New Zealand. Thank you very much, Mr. Fraser Richards, Madam Linda Byrne, Madam Christine Heidman, and Madam Philippa Kurtray for being with us. It is a pleasure that you accepted our invitation, and I will give you the floor for approximately 10 minutes for your opening remarks.
Merci bien, mesdames et messieurs.
Thank you very much, ladies and gentlemen.
Inviting us again to appear before you. I've got about 10 minutes worth of notes. After the meeting, we will send you a fuller document with the details which I am going to give you, so you don't need to take notes, people who are watching.
I would ask you to wait a bit. We just lost the video conference. We'll suspend the meeting for a minute or two while we will reconnect with our witnesses. So we'll be back as soon as possible. continue. Sorry about that.
And again.
You have the floor.
No problem. Thank you. So I'll run through partnership policies, domestic violence policies, comment on our culturally arranged marriage provisions and the work going on to combat forced marriage. And I will talk a little about our prostitution legislation as well. As an overarching statement, our partnership policies, along with all of our other immigration policies, are not prescribed in legislation. We have framework legislation, and we then have certified immigration instructions which the Minister of Immigration authorises. This means that our immigration system is quite flexible, and it means therefore that we can change policies reasonably quickly. We're reviewing our partnership policies at the moment, and this might result in changes possibly next year. So, partnership. For residents, the partnership residence policy allows partners of New Zealand citizens and residents to apply for a residence class visa to live with their partner in New Zealand. Its objectives are to strengthen New Zealand's families and communities, contribute to our social cohesion and development, and attract and retain the skills of New Zealand citizens and residents with non-resident partners. To be granted a residence class visa, applicants must satisfy an immigration officer that their partnership is genuine and stable, that is exclusive and likely to endure. The immigration officer must also be satisfied that they have been living together with their New Zealand partner for 12 months or more. So that's the case whether they're married in a de facto relationship or have a civil union. If they have not lived together for 12 months, we have deferral provisions to enable the qualifying period to be met. Unlike Canada, New Zealand partnership policies do not have a sponsorship element. This is something we're looking at in our review, though. Another difference between New Zealand and other countries is that New Zealand does not have a probationary period for residence visas for partners of New Zealanders, apart from the temporary visas which may be granted to enable them to meet their 12-month living together requirement. The number of residence class visas granted on the basis of partnership in the 2012-13 year was 10,039. This was about 30% of all residence visas granted that year. Each year, around 60% of partnership applicants are women. We give priority in processing, so decision making, for residence applications made under the partner of an expatriate category. In this case, the supporting partner must be a New Zealand citizen or resident who has been absent from New Zealand from at least 2 years. These applications are allocated to a case officer within 10 working days. They'll usually be decided within 2 to 3 months. The reason for this is that we've got a very big expatriate population. Many New Zealanders live overseas, so it's an attraction and retention mechanism for our skilled New Zealand citizens. For a New Zealander to be eligible to support a residence class visa application under partnership policy, they must not have been a partner in more than one previous application, so there's a maximum of 2 foreigners who can be brought to New Zealand under this policy, not have been a partner in a successful application in the previous 5 years, not have been the perpetrator of domestic violence resulting in a domestic violence visa for a previous partner, and meet certain character requirements, including not having a conviction for sexual or domestic violence offences. Under our temporary policies, we have a number of temporary work visas available for partners, partnership for partners of New Zealand citizens or residents, which is around 13,500 approvals last financial year, partner of a worker, approximately 12,000 approvals that year, partner of a student, approximately 1,500. For the purpose of inclusion in an application, a temporary application or residence application, it's a person who's legally married, a person who's in a civil union relationship, a person who is in a de facto relationship, which means living together. They must all be in a genuine and stable partnership. There are no duration requirements for the temporary entry visas, however. Fraud. Partnership fraud is presenting a serious and increasing challenge for New Zealand. Immigration officers report that partnership-based applications are extremely difficult to decline, even if there are suspicions that they may not be genuine. There are high levels of approval, over 95% last financial year. Challenges from lawyers and immigration agents were noted by immigration officers as the major reasons not to try and decline suspicious cases, or not to decline them in any case. Immigration officers say they can find it difficult to assess whether a relationship is genuine or not, despite the fact that under our immigration instructions the onus of proof is on the couple rather than on Immigration New Zealand with regard to proof of the relationship being genuine and stable. Fraud Branch reports that approximately a quarter of the referrals to it are partnership fraud. While the majority of this fraud is ad hoc and individual or family based, there are indications that organised partnership fraud is a growing problem. While the majority of partnership fraud cases involve both partners being complicit in the fraud, Immigration New Zealand is also finding an increasing number of cases in which the supporting partner, the New Zealand partner, is being or has been duped. The level of partnership fraud is impossible to quantify. This is not peculiar to partnership fraud, of course. On the one hand, referrals are often malicious, but on the other, even if it occurs, neither party will report it, as potentially both could lose their immigration status if both of them are foreign. It is also hard to get convictions. Prosecution is unlikely to be successful, as it's very difficult to get witnesses to testify. Victims of domestic violence policy. Only partners of New Zealand citizens and residents are eligible for the domestic violence policy provisions. We don't have any policies for partners of temporary visa holders when the relationship breaks down through domestic violence and they're both in New Zealand on temporary visas. We have two types of visa available under this policy, a work visa and a residence visa. For the work visa, the applicant must be in New Zealand, be or have been in a partnership with a New Zealand citizen or resident, and have intended to seek residence in New Zealand on the basis of that partnership. The partnership must have ended due to domestic violence by the New Zealand partner or a family member, and the applicant must show a need to work to support themselves. An open work visa can be granted for 6 months. This can be extended to 9 months if the applicant applies for residence, which does imply you can see that the residence application decision will be quite quick once it's made. Applications are determined by immigration officers who have received specialist training, and that they are prioritised for processing. Residence category visas. Again, the applicant must have intended to seek residence on the basis of the partnership with the New Zealander, and the partnership must have ended through domestic violence. Further, the applicant must be in New Zealand and they must be unable to return to their home country. So this can be because of social stigma that they would endure if they had to return. The applicant must meet standard health and character criteria, although waivers can be considered, particularly for health conditions. In 2012-13, 62 people applied for residence under this category, and of these 41, which is 66%, were approved. Each year over 95% of applicants are women, but not obviously exclusively women. For evidence of domestic violence, applicants can provide a conviction of the partner, a protection order against the partner, a complaint of domestic violence investigated by the police where police is satisfied that domestic violence has occurred, or a statutory declaration from the applicant and 2 independent qualified people. These can be a social worker, a doctor, a nurse, a women's refuge staff member, stating that domestic violence has occurred. Culturally arranged marriage. People intending to marry New Zealand citizens or residents in New Zealand may be granted a visitor visa for up to 3 months. For this, they must satisfy an immigration officer that the marriage follows a cultural tradition where the arrangements for the marriage, including the selection of the persons to be married, are made by people who are not parties to the marriage. The immigration officer must be satisfied that they intend to marry within 3 months, and the intent is that the marriage will be maintained on a long-term and exclusive basis. So, otherwise, normally we will not permit people to come to New Zealand to get married if they have not met their New Zealand partner. Holders of this visa may be eligible for an initial 12-month work visa as the partner of a New Zealand citizen or resident after the marriage has taken place. This will enable people to satisfy the living together requirements so they can then apply for permanent residence. In 2012-13, 116 applications were received under this category. Of these, 57, so only a third, were approved. There have been concerns that this policy may be used to enable forced marriages. There are protections in place to ensure the consensual nature of marriage. Other than 2 exemptions, which is Quakers and one small Christian church, all marriages must be conducted by an approved and listed celebrant. A celebrant or registrar must not knowingly marry someone under age 16 or under 18 without parental consent. Registrars or celebrants must refuse to issue a licence or solemnise the marriage if they believe the marriage is not consensual. Concerns have been raised about so-called cultural marriages that take place without a licence or approved celebrant. This suggests that those who conduct forced marriages do so outside the law, which may happen in New Zealand or elsewhere. The New Zealand Government monitors the number of marriages involving people under the age of 18. In 2013, there were 57 marriages involving a person under 18. Forced marriage. Concluding observations made by the United Nations Committee on the Elimination of Discrimination Against Women in 2012, the last time we were examined, expressed concerns about reports of forced and underage marriage in New Zealand. While the issue of alleged forced marriages has been periodically raised, there hasn't been any actual evidence of it taking place. The government does remain aware that it's a potential issue. A letter of agreement on forced marriage, signed last year, outlines the governmental multi-agency response to any reports of forced marriage. Immigration New Zealand is a signatory to the agreement and is committed to work with individuals who approach it for immigration assistance, to treat inquiries confidentially, to work closely with external partner agencies to determine any immigration-related issues, and to treat any applications as a priority. Government agencies are working to increase the understanding of forced marriage and to raise public awareness, including obviously of its illegality. New Zealand Police deliver training for staff on forced marriage and the types of violence commonly associated with forced marriage. Specialist police staff are available to investigate cases of forced marriage, and they're engaging with local communities to build trust and confidence. As part of the Migrant and Refugee Resettlement Strategy, the Māngari Refugee Centre in Auckland provides education on forced marriage to all people resettled in New Zealand under the refugee quota. So all of our quota refugees do get specific information about forced marriage and its legal status in New Zealand and our extreme desire to prevent it from occurring. I'll conclude with just a little comment on our Prostitution Reform Act. It was passed in 2003 and it decriminalised prostitution. However, it does include protections for people who are not New Zealanders. Specifically, no one can provide commercial sexual services or, in fact, invest in commercial sexual services or manage commercial sexual services unless they're either a citizen or a permanent migrant without conditions on their visa. And the aim of that was that the legislation was put through as a harm minimisation with a harm minimisation focus, and it was considered at the time that people who were in New Zealand on temporary visas who possibly did not speak English very well were at high risk of victimisation. Okay, finished now.
Thank you very much, Madame Heinemann. Maintenant, nous allons passer à notre tour de...
We're now going to move on to a round of questions, and that will wrap up around 4:20 in order to give us time for the next witness. You have 7 minutes.
I'd like to thank our witnesses for appearing before us today from beautiful New Zealand. I also want to thank you for the early time which you went into the office today to participate in this meeting today. I know that it's about 8 o'clock in the morning, Wednesday morning there. You should know that here in Ottawa, Ontario, Canada, it's just before 4 o'clock p.m. on Tuesday. So we're even meeting on different days here, if you will. We have decided in our deliberations to do a study on strengthening the protection of women in our immigration system. As you might know, Canada is one of the most welcoming countries in the world. But unfortunately, we have seen repeated cases of abuse of our spousal sponsorship program in our immigration system. Last week, for example, we had a witness named Salma Siddiqui, who appeared before us, who discussed various cases of fraud that she has experienced, some of a personal nature to her and her family. And she shared with us a story of in a recent trip that she took to Pakistan. She visited an immigration consultant there, posed as a single Muslim woman, and asked for advice for what options, what some options would be. And the advice she was given, surprisingly, was to engage in a paper marriage and to go to either Canada or Australia, believe it or not. Is this a problem you've seen in New Zealand?
Problem which we are aware of. I'm not sure that it's a very large problem as yet, and I think the fact that people are being given advice to go to Canada or Australia and New Zealand is not on the list is an issue for us with regard to skilled migrants, but probably much less so in the case that you describe. It is. We've always been aware of it as an issue. I remember when we introduced the domestic violence provisions that we've got, we had quite big concerns at that point that they might be exploited by people, particularly from Eastern Europe, because there's quite a large industry which is developing as the internet develops, of organised crime from Eastern Europe, either moving people, which is a big issue for immigration, or simply taking money from lonely people in the West who think that they are looking for love. So,
often in terms of the evidence of kind of these false paper marriages, we often see it as a last-ditch effort, I guess, to remain in New Zealand. So a person will have come to the end of their normal work visas or visitors visas or student visas, and then enter into relationships for the purpose of trying to obtain a further work visa on the basis of that partnership. So that's where certainly I've become aware of the paper type marriages being entered into. So it's when the person is already present in our jurisdiction.
But and as was already mentioned in Christine's little speech that she gave before, it's incredibly hard to actually prove, because it's probably, if you've got half an ounce of sense, it's not necessarily that hard to stage a relationship that to all intents and purposes looks genuine. So yeah, it's an issue that we're aware of and is ongoing.
Could you share with us how you combat marriage fraud or residency fraud that's based on a false relationship in New Zealand, and perhaps you can expand on the wide range of anti-fraud measures you've put in place? Are there any fines involved in that process and so forth?
Yeah.
Okay. Well, we can talk briefly in terms of the residence application itself, or the temporary visa. There is a range of measures that, or a toolkit that immigration officers have in terms of determining the genuineness of the relationship. So that will often involve interviews with the partners together and both separately. It can involve site visits to visit their dwelling and make sure that they appear to be living together. Sharing a bedroom. And they will examine evidence provided, but it is difficult to disprove the genuineness of the relationship. After the fact, as we've spoken about, it's very difficult to then re-examine a case or reopen it and prove that fraud has actually taken place. Because often it is the word of one aggrieved party against another, and it's a he said, she said situation often, and difficult to prove. If we can establish fraud, and sometimes we can trace money changing hands, there are significant fines and imprisonment for providing false and misleading information to an immigration officer. Up to 7 years in prison, $100,000 fine, or both. Is on the table, certainly for the courts. We will have to get you some figures. I don't have them at hand, but I do not think it's very common for us to proceed with fraud prosecutions in these cases, just due to the difficulty in obtaining viable evidence and simply the court process itself. We also tend to focus on systemic fraud in terms of large wholesale organised fraud, such as false job offers, etc. That's our priority in terms of rather than these one-off individual cases of fraud.
Thank you, Mr. Menegakis. Mr. Sandhu, you have the floor.
Thank you, Madam Chair, and good morning to our witnesses from New Zealand, and welcome to this committee, and we appreciate your time this morning. Got a general question for anyone, one of the panels there. In Canada, we have a 2-year conditional requirement for a person to get a marriage spouse to get a permanent residency after they have arrived. And I understand that in New Zealand it's a 1-year live-in situation that requires for the person to apply after they've lived there 1 year. What impact does it have on a spouse if there is a spousal violence in that particular marriage? How does that impact that person?
You mean the person, the partner of the New Zealander?
In regards to if there is a violence in their marriage and having to wait a year,
yep.
How does that impact that person?
Right. It's the domestic violence. Yeah. That was what Christine was referring to before. They're able to apply for a work visa.
That's correct. To get a permanent residency, you do require 1 year. And if there is a violence within that year, how does that impact on that person? Do they require? Does it force them to?
We have domestic violence policies specifically to address that issue. So if someone is living with a New Zealander, is intending to apply for permanent residence, and the relationship breaks down because of what we call domestic violence and what I think you call spousal violence, then there is a work visa available for that person to continue to live in New Zealand, to work, to potentially support any children they may have, and then they can apply for permanent residence. Also, so if the domestic violence allegation is proven to a sufficient level, then the foreign spouse can apply for and be granted permanent residence.
Where is the burden of proof? Is it on the spouse that's being abused, or is it you go through a court system? How long does it take?
It's quite short. Do you want to?
It doesn't necessarily mean they have to have a conviction. They could have a protection order taken out against the partner, or make a statutory declaration that violence has occurred, which has been backed up by 2 independent qualified people.
So although there is a burden of proof placed upon the applicant, the spouse that's been the victim, the level is quite low. It does not require a criminal prosecution for as a basis. We can go as low as statutory declarations from people that are qualified in the field, independent qualified in the field.
So, in other words, it's not a long, rigorous court procedure, so you have to go through.
No.
Thank you.
No, it's quick.
And the statutory declaration can be someone from a women's refuge, for example, or a doctor or a nurse or a counsellor or a social worker.
And what percentage of the spouses sponsored in New Zealand would you say are financially independent?
We don't count that, so we don't. We don't have a minimum income threshold for sponsoring. We don't require the New Zealander even to assume sponsorship requirements, obligations. So it's not something that we measure at all. We could, however, in fact, we could look at it because we have a research database which amalgamates tax data with immigration data and some other government databases. So we could ask our researchers to see how many people paid tax within their first couple of years of being in New Zealand and how much tax they paid. But yes, it's a very interesting question, thank you.
In order to sponsor a spouse from another country, does New Zealand require a language requirement or education requirement from the person that's being sponsored?
No.
Great. What measures, if any, is your government taking to enhance economic and employment opportunities for immigrant women?
We have a broad settlement strategy which is not specifically aimed at partners, but which does have aspects which are aimed at women or people who are, for example, likely to be remaining at home with caring responsibilities during the first period of time in New Zealand. So there's a lot of emphasis on providing information. So there's an Office of Ethnic Affairs which has a big community support responsibility. There is settlement information provided by Immigration New Zealand, a lot of which is aimed at helping people to help themselves to find their way within the community. There is also a lot of focus on employer readiness, so community readiness, in that good settlement is not just something for the migrant, it is also something for the community to be prepared, aware of potential difference and able to build on that difference for the sort of benefits that diversity brings. But yeah, we don't have anything that is sort of a specific program for partners. I think some of this is a difference of scale. We're only 4.5 million people. We have a population which is about 25% overseas born. So we don't have very large communities of particular ethnic groups in general, but but everywhere people go, they will see other people who aren't born in New Zealand.
Mr. McCallum, you have the floor.
Well, thank you, and I too would like to thank you all for being here. We've been struggling with a problem, and I get the impression you might have come fairly close to solving it. The problem we have, one problem, is that if a Canadian has his spouse, or his wife, let us say, come to Canada, they are required to live together for 2 years. And then there's an asymmetry in the power relationship, because if there's abuse or violence, then the one who has come in from a foreign country is at risk of being deported. And so that gives the husband, in this case, a lot of power over the woman, because he might abuse her, but she won't complain because she might otherwise be deported. And if she does complain in Canada, I think the process is expensive and very time-consuming in order to be allowed to stay in this country. And so for many, the cost is prohibitive, and so the domestic violence goes on and is unreported. Now, in your case, if I understand it correctly, the couple has to live together in New Zealand for the first year for 1 year. Is that right?
Yeah, or they may have lived overseas for 1 year. It's just the relationship must involve 1 year.
Because in your presentation, I thought the 1 year could occur before they come to New Zealand.
It can occur in New Zealand, yes. So if they no. So if we have where a New Zealander has been living overseas, for example, and was married overseas, and they live together for a year or more overseas, the partner can apply for residence before they even enter New Zealand.
Okay, so one difference is that in Canada they have to live together in Canada for 2 years. In New Zealand it's up to 1 year or less if they've lived together previously. And the other big difference, from what I understand, and I'd like to ask you this, is that if there is domestic violence, then the woman has assuming it's the woman who is being abused, has a relatively quick and not terribly onerous process by which she is likely to be allowed to stay in New Zealand, because I think I heard you say 66% of the applicants were accepted.
Yeah.
And how long would it take?
Yeah.
Well, I guess we should distinguish. It's relatively easy to get a work visa after the relationship is broken down. However, there's a more, I guess, onerous, rigorous process to go through in order to be granted permanent residence in New Zealand.
It's still 66% getting residence, though. Yes, it is fast. Our residence processes are a lot quicker than Canada's in general. But the other thing about the domestic violence residence applications is that they have top priority for processing. So they have the same priority as a skilled residence application and a refugee residence application once an asylum claimant has been determined to be a refugee. So those are the only three which are top priority, and then the bulk is second priority and parents are third.
What would be I think, sorry to interrupt, but I'm going to run out of time.
Yeah.
Approximately how much time in a typical case would it take for this woman from the point of being abused and leaving the husband to receiving landed immigrant status?
Should be less than a year. Less
than a year. And how much would it cost? A lot of money? How much money would she have to pay?
Excluded from having to pay the migrant levy, which is what people pay once they've been approved, and the cost of the fee is, I think, it'd be family other, wouldn't it? About $800 or $900. Or is it waived?
I think
we'll find out. It can be waived. Can be waived if they're destitute, but the fee is around about $900, I think.
And last question. I'm not a lawyer, but I seem to think the accusation of violence can be a long, drawn-out, difficult legal process. So if they can get through in less than a year, you must have pretty low standards from a legal point of view of proof and so on, which I applaud. I'm not saying that's bad, but how do you manage to get decisions about family violence adjudicated so cheaply and quickly?
Very, very short answer, please, Madam.
It's not done in the court system. It's done by Immigration New Zealand.
Thank you very much. Mr. Leong, you have the floor.
Your witnesses from New Zealand. I do business quite frequently between Canada and Asia, and I know what it's like to wake up at these early hours to be communicating. My question has to do with the provision of information and for foreign spouses. very often we hear from testimony from others that it would be great if the prospective spouse receive information prior to arrival and post-arrival regarding their rights in Canada or in New Zealand, which is probably very different from some of the countries that are coming from. How is that? How do you perform that? And the reason I said this is because these rights for the spouse is to allow them an understanding that they're somewhat protected, at least by the law, when they come into this country. But my concern is that if you have a person who is not conversant in one of our official languages or in English in your case, how do you provide that? How do you deliver that information to them? And what is how much resource do you put behind that?
Not a huge amount of resource, I would say. Some of the immigration branches provide that information to prospective applicants. So I know that in our Indian branches, for example, where people have been applying for visas to come to New Zealand, essentially to, either for cultural marriage or sponsored by someone who maybe has gone to India to marry them and is coming back, they try to provide written information with the visa going back. The difficulty, of course, is that information can be intercepted, and so it's like with fraudulent agents. You can't be certain that the person who needs to get the information will actually receive it. There is some information provided on the internet, and that's translated into a number of languages. So it's translated into about the 12 major languages, I think. So if people can get onto the internet, then they can, and are literate, then they can read it there. As I said, all of our quota refugees receive information, are told about New Zealand's laws, including laws around marriage and around violence and assault. So that's women and men during their 6 weeks that they spend after they arrive in New Zealand at the Bangaree Refugee Reception Centre, before they go out to where they're going to live elsewhere in the country. But I think there is always an issue with regard to... Sorry.
So there is actually an immigration officer that conducts this work, at the post-arrival stage.
Yeah.
Right.
For refugees only.
Yes, but not for other sponsor spouses.
No. For other sponsored spouses, the information that is provided is, in the nature of being on the internet, basically, and there will be things in the community as well if they get join with community associations and so forth. Someone who is very, very vulnerable, though, may have information withheld from them by their sponsoring, by the partner, the New Zealand partner. And the other issue, which is a big one, is that people may come from countries where they do not trust the government and they do not trust the police. So even if they know that these provisions exist, they may not think that they should go and complain to the police because they're worried that that might get them into trouble.
Yes. All right. Well, my next question has to do with how do you determine whether the New Zealand resident is qualified to bring a sponsor, to be a sponsor? I'm specifically asking whether, I guess, do you go and check his background for, mental stability, for means tests, whether he has the income to handle it, or whether there's any history or previous conviction? What sort of process do you go through to make sure that the sponsor? Go ahead.
They're not means tested, so their income isn't tested, but they do get a check on whether they've got any previous convictions of a sexual or domestic violence nature.
So no means
And
test on the
that's
basis of
occurred
income.
within the past 7 years.
Okay.
No, there's no means test. No.
Then my third question has to do with what is the age of consent? Because I wasn't quite clear. You mentioned that 18 they need parental consent, but after 18 they're free to marry as they wish. Is that correct?
That's right, yes. Yeah. So they can't get married under the age of 16. Between 16 and 18, they need parental consent.
There's a case in Denmark. I guess in Denmark, the minimum age is being raised to 25. Do you think raising that age would it help the situation?
I couldn't answer that. I don't know. Yeah.
Well, I guess in New Zealand we haven't got probably sufficient evidence of a big enough problem to do that. And there are lots of young New Zealanders who go away overseas every year as working holiday makers and bring back partners, and they were 23 and they wanted to get married. I think it would be... Yeah. No.
25 sounds quite old.
25 sounds very old.
And
the CDAW have recommended that we don't have any marriages under the age of 18 whatsoever. Yeah. That was one of the recommendations that they made in their concluding remarks.
My final question, perhaps a short answer, please, is can you sort of outline for us, when you mention employment ready for the sponsor spouse, what are some of the criteria you're assessing for employment readiness?
Oh, no, sorry. We don't assess at all for employment readiness. We've got a very permissive partnership policy, I guess. We have recently strengthened parent policy, so now people have to be quite well off to be able to bring their parents to New Zealand. For skilled migrants, we have quite a high bar, but for partners, we regard that on a completely humanitarian basis. So the only thing that we try to make sure is that the New Zealand sponsoring partner is a good person, at least in terms of convictions, and apart from that, we don't require. We don't prioritise people who are more likely to do well in our labour market, for example. It's all on if you're loved by a New Zealander, basically, then you're in.
Yeah. Thank you.
Generous and kind people.
Yes, thank you very much to all of you for appearing in front of our committee. It was a pleasure and an honor to welcome you to that study. And we will now suspend the meeting to welcome our next witnesses. Thank you very much to our witnesses from New Zealand.
Thank you.
Thank you.
Thank you. Merci.
immigration system. Thank you to our witnesses for coming here today. Mr. Lorne Waldman, who is a barrister and solicitor.
Yates, as an individual, appears in front of our committee. De la Maison Afghane Canadienne, Oumaria Madawa, directrice, bonjour. Et par vidéoconférence.
Director, good afternoon. And by video conference.
From Yellow Brick House, Madame Loris Herenda, Executive Director. Monsieur Lorman, je vais vous donner la parole. Vous avez 8 minutes.
Mr. Waldman, I'm giving you the floor. You have 8 minutes for your opening remarks.
To appear before this committee studying this extremely important topic. I see in my practice far too frequently women who've suffered abuse. And unfortunately, our experience has been that in many cases the immigration system compels them to remain in abusive relationships and doesn't assist them to escape abuse and doesn't provide them protection in Canada. And in the limited time I have, I'd like to just give you 3 examples. Recently we were dealing with a woman who came to see us who'd been victimized by abuse, an abusive relationship. She was being sponsored by her husband in Canada, and she was she left the relationship. She left it and went into a shelter because she and her children had been physically abused by her spouse, who was charged. The spouse notified immigration that the sponsorship that he had submitted on behalf of her was being withdrawn. She presented herself at immigration, where she was met by 2 CBSA officers who detained her because they said she was illegally in Canada. There was no consideration of the fact that she was a victim of domestic abuse. She was put into detention, and she was scheduled for deportation. It was only because we were able to get a stay, because the 2 Canadian children's interest hadn't been considered, that we were able to prevent the deportation. We submitted a humanitarian application, which was ultimately successful. She ended up spending several months in detention before she was released, and ultimately she was approved. But the system didn't work for her. It didn't work for her because there was no reason why she should have been detained. There's no reason why she should have been threatened with deportation before any determination was made with respect to whether or not she was a victim of abuse. The system broke down. What we need are clear guidelines that are presented to immigration officers, that in the case of a sponsorship breakdown and where there is allegations of abuse, before any enforcement action is taken, before there's any consideration of detention or any consideration of deportation, the humanitarian and compassionate factors should be considered. I'll give you a second example. A woman came into my office. She was victimized by spousal abuse. She'd been sponsored and come to Canada. She was on a conditional visa. She didn't know what to do. She left her husband. She was afraid she was going to be deported. If she remained in the relationship, she was going to be victimized by abuse. I understand the reasoning behind the 2-year requirement, but I would urge you to reconsider it, because I think when you balance all of the different competing factors, the presence of this 2-year conditional visa often forces women to remain in abusive relationships in circumstances where it puts their lives at risk. The third example I wanted to give you has to do with victims of human trafficking. I've seen in my office over the years several women who were victims of human trafficking and who were forced into the sex trade mostly by the triads. At least those were the women that I saw. And when they managed to escape, obviously they were at risk because they owed this huge debt to the triad if they went back, if they were deported. Their claims for refugee status, however, were rejected because they didn't fit within the neat convention refugee definition, because they were victims of crime and they weren't weren't victims and didn't fall within political opinion or whatever. And so we see these situations where people are being deported, even though they are victims of human trafficking, and there doesn't seem to be any provision in the humanitarian compassionate stream for consideration of the exceptional circumstances that might apply to victims of human trafficking in circumstances where their refugee claims are not accepted or they don't make refugee claims. And I would suggest to you that these are things that can be dealt with through policies by making changes to the immigration manual instructions and guidelines on processing humanitarian and compassionate applications. That would require that careful consideration be given to victims of human trafficking on humanitarian and compassionate grounds. So what we need to do is ensure two things. We need to ensure that there are proper guidelines for consideration of the exceptional circumstances that are faced by women who are either victims of human trafficking and or victims of domestic abuse. And we need to ensure that before any enforcement action is taken to deport or remove these women and or their children, that the enforcement action be delayed until the special circumstances of the abuse are considered. Because the current system, that isn't happening. So those are my opening comments.
Thank you, Mr. Waldman. Madame Madawa, vous avez à votre tour.
Ms. Madawa, you also have 8 minutes.
I would like to thank you for giving me the opportunity to appear before the Standing Committee on Citizenship and Immigration. My name is Humaira Madawa. I'm a director at Maison Afghane Canadienne. We're a non-profit organization based in Montreal, Quebec, and our mission consists of supporting the successful integration of new Afghan Canadians into our society, promoting Canadian values, enhancing and sustaining the self-sufficiency of emotionally, economically, physically, or educationally disadvantaged members of our community, to protect and assist youth, women, and elderly Afghans at risk, and to act as an effective communication bridge between communities. To address the question on how to strengthen the integrity of the immigration spousal sponsorship program in order to ensure the success of sponsored victims or spouses in Canada and prevent vulnerable women from being victimized by an abusive sponsor, I would first like to discuss some current challenges in the Afghan community in relation to the question. Second, I will discuss about the challenges of abused sponsored women, what challenges they face, and finally I will provide a few recommendations on behalf of our community on how to improve the conditions of vulnerable people. The Afghan culture is traditionally very patriarchal, resulting in the dominance and control of women. Afghan men who abuse women typically do so in order to maintain power within the family. Even in this day and age, women typically have traditional role within the household, while men are breadwinners. The Afghan culture also emphasizes collectivism over the Western notions of individualism. Traditional Afghan families reside in joint family households, and extended family members are expected to cooperate to serve the interests of the family. A new bride who comes in Canada has to live with the husband's joint family members and fulfill most the expectations of her in-laws. She has to adhere to the conventions and customs of her home country. However, this family structure might cause additional problems because extended family members may encourage abuse or even take part in it. Such cultural dynamics may encourage women from speaking out as they sincerely believe it is their fate to accept the violence. Arranged marriages are common in Afghan culture, and this practice still continues to persist in North America. It is usual for Afghan men to marry women from their native country, as the women are seen to be more traditional and could fulfill their customary roles even in a Canadian society. When a new bride is sponsored and arrives in Canada, she's expected to adhere to Afghan cultural expectations. She may fail to recognize abuse or even acknowledge abusive treatment. Furthermore, Afghan women face different challenges in reporting abuse and accessing services. Some of these barriers include isolation due to limited contact with family or others, no emotional support, immigration status due to prominent fear of deportation, financial challenges, and fear of losing her children. Language barrier reduces sponsored women's access to services and information about domestic violence. In the majority of circumstances, these women are completely clueless about the resources available to them. Prior to their arrival in Canada, these new immigrants are not informed sufficiently of Canadian values, rights, and freedoms. Furthermore, some abused women do not seek help through the resources of the community because their sponsors and their families have established ties within the members of the community. Immigrant women are thus reluctant to report abuse to anyone outside of the family. They fear that it will bring shame and alienation from their own community. Members of the community, though aware of these injustices against these women, face conflict of interest and choose not to blow the whistle. The combination of all these challenges in a foreign land makes these women vulnerable and helpless to break free from the abusive relationship. The current conditional permanent residency requirement amplifies the vulnerability of sponsored women victims of abuse. Spouses with no children are required to live with their sponsor for a period of 2 years at risk of losing their permanent resident status. Although an exception can be granted to one who can prove that she has been victim of abuse or neglect, this exemption is not always helpful to them. Victims are required to report the abuse in order to maintain their status. Yet this is not an easy task. They're challenged with fear, shame, financial vulnerability, and other obstacles. Furthermore, they have to prove that the abuse took place, and a culture that is still hesitant to acknowledge the prevalence of abuse towards women, speaking out can be the most difficult task. For example, in Montreal, the recent case of family murder case of the Shafias, the first wife was sponsored to Canada on a visa as a domestic servant of the family, and she found herself trapped in an abusive marriage and was too afraid to flee. She ended up becoming a murder victim. There are many other similar cases of polygamy and abuse among the Eastern cultures. On behalf of the Afghan community in Montreal, I would like to recommend a few measures to the committee in order to prevent a vulnerable woman from becoming victimized in an abusive relationship, and also to assure a better integration of new immigrants into our society. First, prior to their arrival in Canada, immigrants should be informed in their language of origin of Canadian laws, rights, values, and available services. They should be informed that they could seek the help they need should they be victim of abuse by their sponsors. There are currently no programs in place to educate these women about their rights in foreign embassies. Furthermore, new immigrants should also be informed of employment, education, and linguistic and social integration programs. Attendance to this information should be mandatory as part of their sponsorship application before they leave their native countries. This measure would not only prevent vulnerable women from being victimized by an abusive sponsor, but also facilitate their integration in Canada. Second, upon the arrival of new residents in Canada, integration courses should also be made mandatory for new residents in order for them to acquire linguistic skills, learn about their rights, educate them on their participation in the workforce. Additionally, counseling services should be available at these centers for individuals in need. As previously mentioned by your witnesses, isolation and language barriers are the root causes of vulnerability of abused women. Through this program, women would not only be forced to step out of their homes, but they will also meet other people, acquire autonomy, and therefore break free from isolation. Abusive sponsor will not be able to oppose this measure, as it will be a condition for the acceptance of their sponsorship. Moreover, as previously discussed, conditional permanent residence requirements should be abolished, as it places these abused women in a vulnerable situation due to their fear of deportation. Additionally, more publicity should be made available on support services, resources, and rights of women fleeing violence. This information should be provided in a variety of languages. And finally, there should be more funds allocated to community services and associations who support and work hard for the integration of its community members in the Canadian society. I thank you for giving me the opportunity to present our opinion on the matter.
Merci, Madame Madawa.
Merci.
Madame Herenda, you have the floor now for
Thank you very much. I wanted to also thank the committee for the opportunity to speak about the issue facing immigrant women. Yellow Brick House is located in York Region, and we provide emergency shelter and counseling services to abused women and children. And just to give you a scope of the work that we do, last year alone we worked with over 6,300 women and children. What we are seeing is that there is a tremendous increase in immigrant women seeking our services, and we have adopted internally to be able to provide the services in over 30 languages currently that our frontline staff offer. I also wanted to take this opportunity to give you a bit of a picture of what's happening in York Region. In 2006, York Region was reported to have the highest immigration population growth rate in GTA. In fact, the fastest growing regional municipality in Canada. The newcomers that have most likely immigrated are from South Asia, China, the Middle East, Southeast Asia, such as Philippines, South Korea, and Russian Federation. Currently, 45% of our population speaks a mother tongue that's other than English or French, and it's estimated about 50,000 people in York Region do not even speak one of those two official languages. The vast majority of newcomers to our region are identified as visible minorities and have racialized identities. So that is our current picture in York Region, and I now wanted to share with you some of the experiences that these women are facing in our community. So some of the issues that they're faced in many countries around the world continue to be characterized by entrenched patriarchy and power disparities between men and women, and both within the family structure and within the culture, the broader society that's supported by culture, the social values, and religious beliefs. So many cultural practices that are socially acceptable in their countries are actually violating the rights of women in Canada according to the Charter of Rights and Freedom. Men who perpetrate violence against women in countries were doing it because it's culturally acceptable, and they've never been charged and convicted. So when they're actually applying for immigration to Canada, that's never taken into consideration the fact that they may be actually active abusers. There's a tremendous amount of stress associated with settlement services and the integration process, and that can often escalate the violence in the family with men that already have that tendency for that behavior. There's an absolute lack of orientation to new immigrants about the laws pertaining to domestic violence against women and children. The family structure and traditional gender roles continue to describe many cultures, and they're often encouraged not to pursue education or employment opportunities. So the man tends to be the breadwinner in the household, and she's financially dependent on him. In many cultures, unfortunately, young women are seen as a commodity to be bargained with through arranged or forced marriages. Underage girls, many of them under the age of 10, are often forced into marriages with much older men, or they're sold into human trafficking. And this is happening with disturbing frequencies. We're getting young women in our shelters at the age of 16 who have already been married for several years and may have children. In some cultures, women are perceived to carry the family honor, which is controlled and protected by men. And if she's perceived to have dishonored the family, she may be assaulted or killed, as we heard mentioning, through honor killing. A woman that's leaving her abusive partner would have been considered to have dishonored her family and could potentially become a homicide victim. If a woman is fleeing a violent home with her children, she's not only fleeing her abuser, she's also fleeing the extended family, both his and sometimes her own. In some cultures, girl children are unwanted. If a woman is pregnant with a girl, she's often forced to terminate her pregnancy. We're also hearing that in many cultures, the mother and father-in-laws are also becoming the abusers, controlling their daughters-in-law, training them in how to become good wives, with a specific focus on keeping family matters very private in order not to cause shame to the family. We also know that many new immigrants settle into neighborhoods where other immigrants who share their culture and language speak, so this leads to social isolation for women and children. And it's also known that children are disciplined more heavily and harshly and physically in many of these cultures because it's accepted in their specific cultural norm. Women who are not educated or employable would likely not be admitted to Canada unless, so their spouse becomes a principal applicant. So they come to Canada as sponsored spouses or family members, and they're economically dependent on them. We're seeing an increased number of Filipino women who their sponsor is typically their employer. As many as 95% of Canada's living caregivers are Filipino women whose isolation, living conditions, economic dependency, and legal status create conditions ripe for perpetration of violence and abuse. If a woman is considering leaving her abusive partner and she's sponsored, her abuser will threaten her with deportation. If children are involved, he will get to keep the children and she will be returned to the country of origin. I think we heard it before that the new immigration laws are making it increasingly difficult for women living in violent homes to get free. Under these conditions, a woman who migrates to Canada as a spouse or partner of a principal applicant is required to cohabitate with her sponsor for 2 years, and she needs to provide proof of this if she decides to leave that. She must also call in the CIC call center to report abuse. If a new immigrant woman leaves an abusive relationship and she has not collected this evidence, she's facing deportation. If a refugee claim is denied and the woman does not have access to humanitarian or compassionate reasons for a period of 12 months to reapply, unless it's in the best interest of a child. And unless you're from a non-designated country of origin, meaning an unsafe country, you have very tight timelines to prepare for hearing, 30 to 45 days. And if you're denied, you can't go to the Refugee Appeal Division, but you need a lawyer to make an appeal at the federal court. And this needs to happen within 15 days of the initial rejection. Human trafficking is another growing problem, where human trafficking victims have a reduced chance of getting temporary resident permit if the law enforcement is not involved in their particular case. We have an increase in abduction of children by the abusive partners, where they leave Canada and drop the children in the countries of their origin. Women are left behind in Canada with no recourse to get their children back. Intimate partner violence is the leading cause of non-fatal injury to women worldwide. Musculoskeletal injuries.
Sorry, I
yes.
interrupt you to say that your time is almost over. If you want to conclude, please.
Absolutely. Thank you very much. As you can imagine, my list goes on, and I would just like to conclude with some recommendations that I heard. I think that the new immigrants in Canada need to get a proper orientation about the Canadian laws and their rights. The services need to be provided in the languages that these women are speaking, and it has to be a single point of access to them, because chances are, if they're isolated in their communities, they will not be aware of the community services. And we do need to look at the revision of the immigration rules that are punitive for the abused women and children. Thank you very much for this opportunity.
Thank you, Madam Hernanda. We're now going to our first round of questions. Mr. Minagakis, you have 7 minutes.
Thank you, Madam Chair, and let me say a big thank you to our witnesses for appearing before us today. As you can appreciate, this is a very important study for us. The Minister of Citizenship and Immigration, the Honorable Chris Alexander, held some roundtable discussions on this very topic in the month of January of this year, and heard much of the very similar things that we've heard from you today and from other witnesses that have appeared before us. This committee, in its deliberations, felt it was important to do a study on this subject. Clearly, there is abuse, there is a problem in the system, and we'd like to identify possible solutions. And some of the recommendations you've made here today are certainly very important, and we will consider them as we conclude our study within the next number of weeks. Having said all of that, we do have a challenge. There is abuse in our immigration system. There's a reason why the conditional PR was put into place in the first place. Its objective, of course, is to deter people from using marriage of convenience to gain permanent residency in Canada. That does happen. We have many, many, many cases of that happening. Something needs to be put into the system to ensure that Canadians are protected and there is an abuse of our immigration system. At the same time, we're very cognizant of the fact that the different cultural backgrounds, as I think you mentioned, some very live examples, Ms. Madawa, prevent women from properly disclosing that they are in an abusive relationship. So I'm going to direct my first question to Mr. Waldman. Mr. Waldman, welcome back. I know how keenly interested and involved you are with this type of work in your office. Let me ask you this. How do you feel we can combat marriage of convenience if the conditional PR was to be eliminated?
Well, marriages of conveniences have been combated before the visa through two different procedures. The first was the careful scrutiny by visa officers who have the power to refuse issuing a visa if they believe that the marriage is non-genuine. And that's been happening as long as I've been practicing immigration law. And of course, the sponsor has an appeal, and then the Immigration Appeal Division decides whether the marriage is genuine or not. So that process exists independently of the conditional visa. The other important fact was that there is also the possibility of enforcement action being taken. And I was in Vancouver last week on a case where there was an allegation that someone got permanent residence based upon a non-genuine marriage, and he was subject to deportation. And when I started practicing immigration law, that virtually never happened, and now it's happening all the time. So the ability to enforce and to deport people who engage in marriages of convenience exists independently of the conditional visa. All the conditional visa does is make it easier, because if you leave prior to the 2 years, I assume there's a presumption that it's a non-genuine marriage, and you're deported unless you can prove that you've been the victim of abuse. So the problem with that, and I understand the motivation behind it, as you said, but the difficulty with that is the byproduct of the conditional visa is that we're perpetuating the abuse. So as a committee, as a society, we have to make a value judgment at the end of the day. It's not that we're without mechanisms of enforcement. We have mechanisms of enforcement. The mechanisms of enforcement are the refusal of the visa overseas and the admissibility proceedings. Are those sufficient? I would say they are, and I would say when you do a cost-benefit analysis of adding the conditional visa, the benefit of making it easier to deport someone if you believe it's a marriage of convenience is outweighed by the danger. I mean, I asked you this. If one woman is forced to stay in an abusive relationship and gets killed, is that going to be what it's going to take for us to have to get rid of the conditional visa? That's my sense. Okay, sorry.
Okay, let me just touch on something that I believe both Ms. Herenda and Ms. Madawa touched on, and I think you did as well, Mr. Waldman, and that is informing people before they come here of what the Canadian system is. I think Ms. Herenda used the words the orientation of our laws and rights here in Canada. I think it's important because, quite frankly, we just cannot ignore the fact that marriages of convenience happen, and will happen considerably if we eliminate the conditional PR. One of the things we can inform people on, for example, is right on our CIC website, there's an operational bulletin, and it provides the exceptions from which the conditional PR is lifted on the abused individual, and there's a whole slew of exceptions, and it's not limited to those exemptions. For example, there's any kind of court document, protective orders, releases, bail orders, that kind of stuff, but perhaps it's a little bit more advanced for people, you know, they're not ready to run to lawyers and to run to courts to disclose their abuse, but they can provide a letter of statement from a women's shelter or domestic abuse support organization. I know Ms. Harenda, I'm keenly aware of the great work that Yellow Brick House does in York Region. A letter of statement from a family services clinic, a letter of statement or report from a medical doctor, a sworn statement, an affidavit from them or from a family member or a friend, photos, injuries, voicemails, emails. There's a whole slew of things that can be very useful tools to a person who is being abused. So I'm going to ask my last question to you, Ms. Harenda, very, very, very shortly. When you do get a woman who comes to you who has been abused, what advice do you give them about the next steps they can take before they, of course, are threatened with removal from the country?
Very short answer, please, Madam Harenda.
Oh, absolutely. Thank you. One of the things that we offer, one of the services that we offer at Yellow Brick House, we do provide them with free legal clinics. So we have lawyers in our community who are committing their time to speak to the women and talk to them about their rights. We also connect with legal service organizations, the Legal Aid, or SELCO, for example, the South Asian legal community, to provide information. But it's increasingly difficult because legal aid is really limited in terms of what they can access if they have any rights to access them. We're seeing a growing number of women who are coming to the shelter who don't have any status in Canada because its application has never been submitted. So they're starting from scratch, literally. Those are some of the challenges that they're facing right now.
Mr. Sandy, you have 7 minutes.
Thank you, and I will be sharing my time with my friend Mr. Harris here. Thank you for being here this morning, and I'm glad that the government has pointed out that the Minister of Immigration has taken consultations in regards to abuse against violence against women. And from the government's record, we've seen it even this morning. The Prime Minister was unable to identify even one witness who actually supported the Unfair Elections Act. And hopefully that won't be the case in this study, because I know every single one of the witnesses that has appeared in front of this committee has been very critical of the 2 years that are required for a spouse to be in a relationship where they may be abused and they may be unable to get outside of that relationship, fearing that they'll be deported. I know both of the witnesses here and also one out through the video conference is against such provision, and hopefully the government and the minister is listening to all of the witnesses in this committee. I want to get back to the issue about isolation, and you talked about how women are isolated from the community and also family, and we've seen the record under this government where the parent reunification, family reunification, it takes 8 years for a family to reunite with their family. You think that family reunification will help reduce violence? If a person, a spouse, is isolated here, having that family here will help reduce violence against women?
Well, for our community, I would say it would definitely help taking those women out of isolation. Now, the problem with a lot of the Eastern culture is that it's socially accepted. You know, it's part of the culture. These women remain silent about it. So I think they should be more maybe informed. I mean, it would be good to have their family here. There's also, like, MAFCAN works to bring the community closer. We organize events, you know, where they come and they have religious gatherings, all kinds of events where they come and kind of helps to be out of the isolation. Now, I think what would be more helpful is maybe if they're more informed of their rights, of Canadian values, because oftentimes, even though members of the family do agree that, you know, there's violence, they will still accept it. They see it as part of the culture, unfortunately.
You being a lawyer, we heard this morning from the New Zealand delegation that in order for them, if somebody is being abused in a situation where they actually have 1 year where they have to live with the spouse that has sponsored them. But if there's abuse in that 1 year, the threshold for them to prove is very low if they are being in an abusive relationship. In addition to that, it doesn't require for that person to get a PR to go through extensive court hearings, or it doesn't cost them a lot of money. You think that's a good idea for us to have here?
Absolutely. I mean, of course, we're talking here about two different issues, because some of the women who come are victims of abuse and they flee their country and come here and make claims for refugee protection based upon abuse. Those women have to go through the refugee process and have to establish that they are victims of abuse, and have to establish the facts to a balance of probabilities. Women who are in Canada who are sponsored and who are victims of abuse, there are also two scenarios. The women who were sponsored came as permanent residents, as sponsored. They're now on the conditional visa. So that it's not clear what the burden of proof is on them to establish abuse. It's not clear from the regulation and from the policies to what level they have to do that. The third scenario are women who are in Canada, who are sponsored in Canada, and they're being processed in Canada. Those women are the most vulnerable because they don't have any status. And if the sponsorship is canceled at any time, then their case is closed and they can be deported. That's what happened to my client. And so in those that's the biggest problem, where the greatest vulnerability is, and that's where we need to have a clear policy that if that happens and the sponsorship is stopped in the context of abuse, there has to be a public policy that requires that before any removal takes place, that the woman be given an opportunity to establish the abuse. And I would agree to the same lower threshold.
Thank you, and thank you for everyone for coming today. Mr. Waldman, I'm going to start off with that first case that you raised where the person left the abuse. And I mean, it's difficult for women who are born here, who have Canadian values and culture, to actually leave abuse. It's incredibly challenging, and I can only imagine the additional burdens for someone who is out of their culture, out of their language, to be able to take that step to actually get out of the abuse. Now, you mentioned the person was detained, incarcerated. Would the prospect of that kind of incarceration have the great potential to re-victimize that person?
Oh, there's no question. I mean, this woman was traumatized by the whole, I mean, she'd been abused. She was in a shelter. She went to immigration to tell her story, was arrested, and then re-traumatized when she was detained with her children in the detention facility and threatened with deportation. And the issue was, of course, whether she was going to be separated from her children. So the whole experience as the processing by CBSA of her case was very traumatic.
The children were put in detention with her?
Briefly, then they were allowed to go when we found someone to care for them. Yeah. Okay,
so a family member or foster care, some situation. At least they weren't completely removed. Ms. Randa, you obviously work with abused women quite a bit, and what are some of the language barriers that are faced? Because Mr. Menegakis talked about the website and all the wonderful information on the website. But if you don't read, speak English or French, it's going to be absolutely of no use to you. And certainly it would be important to have clearer guidelines, to have better education programs, to have better information for people. But what are the folks that are coming in that speak all these different languages? How difficult is it for you to serve them? And, of course, what kind of additional costs does that run for Yellow Brick House to provide those services?
Once again, very short answer, please.
Absolutely. Thank you for the question. It's certainly a challenge because we had to increase the qualification level for our staff, if you will. I mean, not only are they qualified counselors, but each staff member must speak another language besides English. So as I mentioned, we were able to work with women providing 30 different languages, but still that's not all inclusive. So there is the additional cost of utilizing interpreters when we're working with these women and these families. And although the CIC site has a lot of the resources, again, there's the language limitation that is present. And there has to be the cultural appropriateness. It's not just the language, but also being able to provide the services in a culturally appropriate manner so that this woman and these children can relate to that.
Thank you very much. Mr. McCallum, you have the floor.
Well, thank you very much, and welcome to all of you. And in particular, I certainly am an admirer of the work done by the Yellow Brick House. And I wanted to begin a question for Ms. Herenda. The other two have already said they opposed a 2-year living together rule. I just want to ask Ms. Herenda if you oppose it or are in favor of it.
I oppose it. Particularly I'm talking about women.
Very short time. But I've asked 15 witnesses now, just yes or no. And out of the 15, 13 said get rid of it. 1 said keep it, and 1 didn't know. So there's a very strong majority, and I definitely agree with that majority. And if you tell me that in return for this rule you get a smaller number of marriages of convenience, but you have to pay a whole lot more abused women, I say that's a terrible deal, and get rid of this 2-year rule. But the main point I want to make in my short time is that I don't know how many of you heard the New Zealand testimony, but it dovetails perfectly with the issues that you are raising. And I just sent a message earlier to my staff to summarize the New Zealand testimony. I'd like to just read it to you. In New Zealand, couples have to live together for 1 year versus 2 here, and in the case of alleged abuse, a spouse can get 9-month open work visa easily. An application for permanent residence of an abused person is decided in less than a year at a cost of $800, and 2/3 of applicants succeed. We'll compare that with Mr. Waldman's first example. It's black and white. And I said, how come so fast and so cheap? And the New Zealanders said part of the answer is they don't use lawyers. This is adjudicated by immigration officials. So I think we only have about 3 minutes left, but I'd like to use that time to ask Mr. Waldman, having heard the New Zealand thing, to what extent could it be implemented in Canada and how would we do it? And to Ms. Madawa, would a system like that, to what extent would it solve the problems you raised regarding the Afghan community? I think more things would be necessary, but it might go a significant part of the way, and I'd like to ask you that.
Very briefly, it could be implemented through a public policy that the minister would promulgate that would indicate that in the case of an abused woman who is in a marriage, that officials before they take any enforcement action, they be required to interview the woman and determine whether or not there are allegations of abuse, and if they believe that there are reasonable grounds, which is a very low threshold for that there was abuse, that they be directed to process her application for permanent residence on that basis. It sounds to me what they're doing in New Zealand. I've just summarized it. If
you compare it with your first example, it's night and day.
But the problem here is there's no clear policy, and what we have, the biggest issue is we have the enforcement CBSA working completely independently from CIC. So there's no coordination between the two. So
to what extent would this address successfully some of the challenges you raised?
I believe it's already an improvement. I mean, going from 2 years to 1 year, it's a shorter time.
Let's say we go to 0. I'm talking about the fast process to get landed immigrant status if you're an abused woman.
Well, like Mr. Lawrence mentioned before, it's a cost-benefit situation. We have to analyze cost and benefit. If we get rid of it completely, there's other measures that, there's interviews in their native countries before they're sponsored to see if the marriage is a marriage of convenience or if it's a real marriage. So I think there can be other measures that can be implemented instead.
Okay, thank you.
Minute.
Oh, I thought I was going to run out of time so quickly. Okay, I'll give it up. I think you've covered the issues I wanted to raise. Thank you.
Thank you, Mr. McCallum. Mr. Shore, you have the floor.
Well, thank you, Madam Chair, and thank you to the witnesses also. Through you, Madam Chair, seems like the opposition's has sole agenda is to talk about the conditional residence in Canada. But I want to share one thing that numerous witnesses in this committee they have mentioned and they have identified issues like language barrier, lack of information in foreign languages. Then they talked about fear of being stigmatized or marriage breakdown, parents desperate to get their daughters married in Western countries. Then they also talked about lack of employment and training, recognition of foreign credentials, of course. All these other issues which I have not heard once even from my colleagues from the opposition. So my first question will be to you, Ms. Haranda and Ms. Madawa, that what is your opinion that what can we do better to educate women pre-arrival to Canada or at least very soon after they come to Canada to ensure they are aware of resources at their disposal should they be abused? I'm sure, I like Ms. Madawa when you mentioned something about mandatory integration program, etc. I mean, what is your proposal?
Like I mentioned before, this should be part of their sponsorship application in their native countries when they're applying. I'm sure there's interviews and other steps that are taken. But the integration should be an integration course or maybe information session should be mandatory, where they're informed of Canadian values, of rights, and also, like I said, employment opportunities, because employment would make these women less vulnerable financially, and it would also help them step out of isolation. So I think it would be a good idea to implement this in foreign embassies.
What is your opinion, Ms. Haranda?
Well, particularly in York Region, we have wonderful welcome centers, which are settlement services for new immigrants, and they utilize them extensively. And one thing that's lacking in these particular centers is actual support systems or counseling service to women who have disclosed abuse, or the whole interview process doesn't really identify any risk factors associated with domestic violence, so they're only addressing settlement, language, employment, job-seeking opportunities, but not the relationship and the cultural component. So I think that educational part has to be introduced simultaneously in those centers.
And Mr. Waldman, I want to talk a little bit about the process of exceptions in this conditional residence requirement. And I'm sure you also know, and you actually said that you understand the reasoning behind conditional visa. I'm going to read you a list of acceptable evidence in cases of abuse or neglect. It is not exhaustive, I should note, but it provides a good picture of the threshold used to determine abuse or neglect by a sponsor. Let me start with evidence of abuse or neglect, or that the sponsor failed to protect from abuse or neglect. Court documents or protective orders, including release, no contact, or bail orders, orders pending trial or appeal, recognized orders or peace bonds, probation orders following conviction, conviction certificates, victim impact statement. Of course, it must clearly state that abuse occurred or is believed to be occurred. Letter or statement from women's shelter or domestic abuse support organization. Letter or statement from family services clinic, letter, statement or report from a medical doctor or a healthcare professional, sworn statement, affidavit, police or incident report, related documents, reports indicating passport and travel documents were withheld and the police had to help to retrieve them, photos which show the victim with injuries, voicemail or hard copies of email, affidavit from a friend, a family member or a neighbor, a co-worker, staff member or supporter, agency, law enforcement, etc., etc. So, giving this wide range of options available to use the exception, it is my opinion, with all due respect, Mr. Waldman, that this does not constitute an exceptionally high threshold of proof.
You know, I understand what you're saying, of course, but you know that what the first difficulty with that is that the woman isn't aware of all the exceptions, but she's definitely aware because she's told when the visa is issued, and she's told when she comes into the country. She's aware that she has a conditional visa and she has to stay with her husband for 2 years or else she'll be deported. And so the husband holds that as a sword over her head for 2 years. So yes, you're right. If she gets access to a website, if she can read the website and understand, there's lots of evidence. Of course, as a lawyer, I can tell you that at the end of the day, it's going to be in the discretion of the officer whether he or she accepts the evidence, and there's many cases where they won't. But assuming that we leave that aside, the difficulty that we have in all of these cases is that the woman's aware of the threat from the moment she arrives, that she has to stay with 2 years, and she may not be aware, and she may never have access to the information that will free her.
So the message I get from you, Mr. Waldman, is that in reality, this conditional visa is not an issue if the women are aware of, if they are educated before they come to Canada, that they have the rights, they have the resources they can use in Canada. Then the conditional visa could not be that big issue.
Well, I think it would help if we were sure that in every case the woman was made aware in advance that if she's a victim of abuse, she has recourse. I think that would be an improvement over what I think is the general rule now, where most women are aware that they have this condition and aren't aware that they have any recourse. Having said that, I've dealt with many women in abusive relationships, and I find it so distressing because the woman has the courage to leave, and then a week later she goes back. And it's such a horrible situation of vulnerability. By adding this, you're just making the woman more vulnerable. I just can't. If you haven't dealt with women who are in abusive relationships, you can't understand what I'm saying.
Thank you very much. Thank you, Mr. Short. Time is over. Mr. Harris, vous avez la parole.
Mr. Harris, you have the floor, but we will be interrupted by the bells at some point.
Across the way, talking about all these, these exceptions and these wonderful things that are there for people to break free. But if you're a person who's come from another country and you know nobody here but your spouse, and you're in that home and you don't speak the language and you're completely and totally isolated, you're not going to know about these things. You're not going to have access. And as Mr. Waldman said, the only thing you do know is if you leave, you'll be deported. That's the only thing that they do necessarily 100% always know about. And Mr. Shorey talked about our sole agenda of seeking to remove the 2-year conditional PR. Well, it's very easy to see that when witness after witness after witness tells us that this is a problem. I don't know why you guys have such a difficult time listening to what witnesses say, whether it's here or about the Elections Act or about Canada Post or whatever the issue is. You're just going to keep going on.
Point of order, Madam Chair.
Oui, sur un point d'ordre.
Yes, it's a point of order. I think the member is abusing his time here. He's using it for political partisan reasons, and I would have him rethink his approach.
Merci, Monsieur Menagakis. C'est pas tout à fait un point d'ordre.
Thank you. That's not exactly a point of order. I've allowed for a certain amount of flexibility. Could you please address your remarks to the chair and remain on topic, please?
Certainly appreciate if the government changed their approach and attitude to issues like this, so that we could actually get to addressing violence against women
again.
And.
Monsieur Menagakis.
Yeah, it's a point of order again. We have witnesses here. I would ask the member to question the witnesses, make his comments there. If he wants to discuss things regarding the government, I'd be happy to excuse the witnesses, and we can have that discussion between us here.
I was just mentioning
encore une fois, Monsieur Harris. Vous pouvez vous concentrer sur le sujet de l'étude, les questions.
I just said violence against women.
Merci, Monsieur Harris.
Thank you, Mr. Harris, and please continue with your questioning.
I haven't spoken or asked you any questions yet, but many people coming from Afghanistan have to be processed through immigration offices that have horrendous wait times. Islamabad oftentimes can be 40 months or more. Do you think that any of those offices, based on what Mr. Shorey said, might even have any resources to provide people with the information beforehand, considering how long it takes them just to approve immigration applications?
Through the Afghan community, I haven't heard of any cases where they had any information sessions provided in the embassies. I don't think I have heard of anyone who attended an integration course or anything alike.
So they basically, it's only would be on this side that they might have recourse. And again, that's only if they know about services like the ones that you provide, or in Richmond Hill, the ones that Ms. Arenda provides, or in my community, Dr. Ross's Healing Place, or Access Point on Danforth, all providing immigration and settlement services and giving immigrants a place to come in, join together, and to share each other's stories and learn about what's going on in their communities. But what would be the single greatest thing that you think would help your community in addressing these issues of violence?
Like I mentioned earlier, I guess a mandatory integration course, whether it happens pre or post immigration, but this should be made mandatory so that they have no other choice. They come out of isolation. They learn about their rights. There should be language classes that should be mandatory as well, and maybe be made aware of their employment opportunities and employment skills here in Canada.
Ms. Arenda, the same question to you. What would be the single greatest thing that would help you in servicing your community?
In addition to having access to the orientation about their rights in Canada and the rights for their children, the fact that they have a right to lead a violence-free life, I think we also need to provide information on, in case they do have to leave that relationship down the line, 6 months or so, they decide, okay, this is the way I have to go. They need to know where to go, and it has to be culturally appropriate and it has to be accessible to them. Giving a woman a phone number to a crisis line is not going to cut the bill on this case, because a new immigrant woman is likely not going to be making that call. So we have to be available to and accessible to her.
Thank you. Mr. Sandhu.
Mr. Walden, the same question to you, if you would like to answer that yourself.
I agree with everything the co-witnesses have said. Access to information is vital. Women are extremely vulnerable, especially when they come from certain societies where they're in a position of complete dependence, and ensuring that they get access to the information.
Sorry, Mr. Waldman, I will have to interrupt you now. The bells are calling the member in the House of Commons for votes, so I will have to put an end to our meeting. Thank you very much to all of you for appearing in front of this committee and getting involved in that very important study. So on that, je déclare la séance ajournée. Merci à vous.
The meeting is now adjourned. Thank you.